Hello, everybody. Welcome back to Courtroom Confidential and Wednesday Night Live, the fastest growing live legal streaming show on YouTube. I don't know if that's true, but go ahead and fact check me. I don't think you can prove me wrong. I'm going to keep saying it till somebody tells me to stop. Thank you, everybody, for being here. Again, for sacrificing part of your evening on a Wednesday to come and chat with us about all things true crime and legal news. And we have a doozy for you this evening, a lot to get into. First of all, some just updates. I was on STS, Surviving to Survivor, earlier today, talking about the Sarah Boone case. She had a hearing today. We're going to get into that later, sneak peek. And it was a fun chat. You guys should check it out. When you're done watching this one, go ahead and check out that live stream that we did earlier today and leave some comments about, representing the Courtroom Confidential crew that we have here. But welcome everybody to the chat. I see a lot of familiar names: Cajun Girl and the defense attorney Meow and Afton. Thank you all for joining again. In that same vein, I wanted to give a shout out. Hello, Jody. Oh, thank you. You saw STS. Thank you so much. I thought that was a really interesting conversation. I want to give a shout out to some of our newest members. Those are Bonnie Hins, Kookie, Irene Calexico, and Todd Hudat Clement. Thank you guys so much. Always appreciate the support. Katie saw the STS segment. I thought it was a really interesting conversation with a couple of gentlemen that I had not met before. So it was fun to chat with people that you have seen doing commentary on YouTube, but I've never actually had a chance to speak with myself. Thank you so much, Cynthia. I appreciate the support. Okay. I got criticized last week a little bit for taking too much time to warm up, but it's just nice to hear from you all, and I'm trying to give everybody time to get logged on. But here's what the plan is for this evening. We got lots of cases were in court today. Harvey Weinstein and Brian Walshe and Shanna Gardner and Sarah Boone and all of these different cases. For some reason, Wednesday was the day to handle a lot of business. We're going to talk about some updates on some of those, but then the plan is to get into Sarah Boone and actually look at her testimony from earlier today, because I was shocked that she actually took the stand during this hearing. Now, I've called it that this woman's going to testify. So I don't know if I get to call in all those bets that people made with me about whether or not she would actually testify if this counts. I'm going to say it doesn't count because it's not during trial. She's not in front of a jury. But this further it builds my confidence in the idea that this woman cannot help but enjoy the limelight, and she will put herself on the stand during her own trial. And so it was remarkable that she testified during this hearing, which is essentially a Miranda hearing. I've done many Miranda hearings. Very few of them do you even call witnesses, and I've never seen one where the defense testifies. For the defendant to testify at all before her trial is remarkable, because this is sworn testimony. This is prior testimony. This is impeachable evidence. If she does testify now, they can use everything she testified to on the stand today that we're going to play for you against her if they needed to. I have also not watched this entire thing, so we're going to watch it together for the first time, and I'll try to interject with what I feel are some thoughts, but also give you some time to let it all soak in all of its Sarah Boone goodness. All right. First of all, Shanna Gardner. Shanna Gardner is the woman out of Florida who is accused of orchestrating and taking part in the execution-style murder of her husband, Jared Bredigan. She did that with her current husband at the time, Mario Fernandez, and it's a awful murder. They set him up. He was driving with his 2-year-old, by the way, in the car seat, in the car when he was executed. Just all of it's heartbreaking type of stuff, but it's also this elaborate plan reminiscent of Adelson. A lot of people have talked about that. And coincidentally, this coming Monday, as part of our case note series that we do here on Courtroom Confidential, we are going to get into the entire Shanna Gardner case. I'm very happy with the episode. It's a very deep dive into all of the surroundings of the case. I think it's going to be the next big case when this goes to trial. And by the way, here's the big news. A trial date was set for today, and it is coming up. How timely is our video? It's coming up on October 20th. Oh, wait, let me check my notes, of 2025. So womp, womp, womp. Our timing is not that great. We missed it by just a year, but the trial has been set a year out from this month. So disappointing in that we'll have to wait, but also not surprising in that this is a double defendant death penalty case. So a lot of stuff for defense attorneys to prepare for. Jose Baez is Shanna Gardner's defense attorney. So you have that to look forward to around this time next year. Right. But doesn't mean that you shouldn't get caught up on the case this coming Monday with the premiere of the case notes episode that we did on this, because we still put in a lot of work. I would like you guys to enjoy it. All right. Brian Walshe was also in court today. Brian Walshe, you remember, is accused of murdering and likely dismembering his wife. And when I say likely, that's because they've never found her body to this day. He's out of Massachusetts. We did a episode, a case notes on his case, also fascinating. And he, there was this whole idea that she was visiting. She had been working in Washington, D.C., living in Massachusetts. She would fly only in for the weekends to be with her family, then fly out to go back home or go back to work. One of those flights she missed. Her work calls into the police to say this woman is missing. We can't find her. They interview Brian. He says, I don't know. She took off to the airport, and all of the mystery starts to unfold, including a bunch of incredibly damaging internet searches, because that's my favorite part is no matter how clever these guys are, they still don't realize how permanent stuff is on the internet. But Brian was at least smart enough to say, well, I'm going to use my son's iPad and maybe they won't look into that. Well, wrong, Brian. But he's also making a lot of news for his connection to another case that, if you have not been living under a proverbial rock in the true crime world, you may have heard of, and that's the case of Karen Reed. And the connection has to do with the lead investigator on both of these cases is a state trooper by the name of Michael Proctor, who, if you've been following the Karen Reed case, that should give you post-traumatic stress disorder just to hear his name after everything that has taken place with him. Hi, Shell. I myself have never worked on or tried a no-body case, either from the prosecution or defense side. I have assisted when I was a law clerk on a couple of them. They are fascinating cases to work on because, end of the day, the defense always gets up there and says, you don't even know if this person is dead or how they died. And that's still a lingering question in everyone's head, and it will be in this case. But the reason why Mr. Walshe was in court is that his newest attorney, Larry Tipton, brought a motion, and he's asking for a bunch of stuff, and it has to do with Michael Proctor. First, he is asking for a complete copy of all data referred to in the Commonwealth's notice dated September 6, 2024, described as, quote, extraction of Trooper Michael Proctor's work cell phone. He obviously was watching the Karen Reed case as well. He realizes that Michael Proctor has a little trouble keeping his thumbs quiet and likes to talk a bit of dirt about the people he might be investigating, which got him into some very deep, heavy, hot water, in the Karen Reed case, which, not to get into the whole Karen Reed thing all over again, but it was such a distraction to the Commonwealth's case that this nonsense was taking place. And it was something that the defense, and I applaud them for it, used to their benefit as much as they possibly can. And it's so unfortunate for law enforcement that noise became such a part of that case. In addition to wanting Michael Proctor's insider cell phone, Mr. Tipton also wants more than 3,000 pages of U.S. Department of Justice's materials of their investigation into the Karen Read case. You remember during the Karen Read case, there was this kind of backdrop noise that people referenced and talked about, but it never made it into the actual trial, that there was a federal investigation into this case as to the way that it was handled. And we've never really learned much about that other than the feds have done nothing with it, and other than it didn't play a role in Karen Read's case, which to me means the judge knows what it says or the findings of it and didn't feel that it was relevant. But Tipton, who is Walsh's attorney again, says, I want that too. I want, listen, if they're investigating this department, I want to know what they were investigating. We're going to get into why he even feels like he can ask for this stuff. The Michael Proctor connection is pretty obvious. It's the same lead investigator. This guy's been up to no good. I want to know what no good he may have been up to in my case. Now, when it comes to the Department of Justice materials on Karen Read, we'll talk a little bit about why he feels like he should get into that. And the third thing that he asked for might give you some further insight. He then asked for any correspondence or other written materials regarding the investigation into the case of the suspicious death of 23-year-old Sandra Birchmore. You remember that Matthew Farwell, who was a state trooper, also he was recently indicted for her death. That is a case that is tragic, awful, fascinating, and that we will be talking about much more on this channel when it starts to heat up a little bit. But Mr. Tipton is saying, I want that stuff too, because that has to do with this entire department. And that's what he's doing. And it's interesting because Walshe was all but dead in the water. His original private high-priced attorney had left. He'd run out of money. The case looked incredibly strong against him. And now this attorney is trying to resurrect this defense by saying, as they did in the Karen Read trace, basically putting the entire department on trial. I want Proctor made a part of this case. I want the investigation the feds did into them. And I want to know what was going on with this other officer who killed somebody allegedly. And it just goes to show you how much corruption could there be in such a small department, asked defense attorney Meow. Yeah, that's the point, is this department's got some major problems. And it shows you how it could rip an entire department apart. Now, any good work that they've done. Brian Walshe, watch the episode we did. This guy's guilty as the day is long, as far as I'm concerned, and I'll try to reserve judgment because that's what we should always do until we hear all the evidence. But we know so far, there is a mountain of evidence against this guy. It may affect that case. That's how fundamentally important it is for these officers and departments to be clean, because when they aren't, and when things start to get dirty, and you have things like Michael Proctor on the low end of spectrum of awfulness, and then things like Matthew Farwell on the far end of the spectrum of awfulness, causing one department so much grief. It's going to be one of those, we had this happen here in Los Angeles years ago. I'm blanking on the name of the officer, but it put the entire department under federal supervision for a long period of time. And that's what happens in these types of cases. I imagine that's what will happen here, is they'll be under some sort of special supervision by the DOJ for a period of time until they get their house clean. They've got a clean house, because it's going to be allowed for them to go through all of these other officers. In this case, they're already talking about assigning a special master so that an independent review can be done of Proctor's phone to see if there's any evidence that might relate to Brian Walshe. What an absolute mess. And just, let's have some perspective on this here. This never would have been an issue before Karen Read. But for whatever reason that they were able to get Proctor's phone in Karen Reed and discovered and exposed everything that he was about. Lee, thank you so much for joining up. That, oh, Kat, thank you so much for that generous donation. That's very kind. That is the only reason why on the Walshe case they're getting into his phone this time around. You don't. I've been a prosecutor, defense attorney, never had a request or subpoena for the detective's phone. That's just not material. And now it's becoming material because of what happened in that case. And rightfully so. I mean, if you are representing anybody who has been investigated by that department in the last few years, or certainly anybody who had anything to do with Michael Proctor, I think it's damn near attorney misconduct to ineffective assistance of counsel to not be asking for this stuff at this point. And especially when it sounds like the judges are going to start handing it out. So there's Brian Walshe, a case that I thought was just going to kind of linger around till it got to trial. And now it's really starting to heat up. But let's get into the real big news that took place today. Kaylin, if we have any other questions on Brian Walshe before we get into it, let me know. But here's what, or before we get into Sarah Boone. So, Sarah Boone, we talked about this on this channel before. She brought a motion, her defense attorney, asking to have her interviews kept out for a violation of Miranda, meaning she wasn't properly advised of her Miranda rights. Therefore, her entire statement should be kept out. Now, why does she want her statement kept out? She wants her statement kept out because her brand new defense is that this was self-defense working in Congress with battered spouse syndrome. And basically, I was so in fear from this systematic cycle of abuse that I was suffering in the home that I couldn't unzip the luggage, because if I did, I thought he would kill me. Okay. And so therefore I acted in self-defense by not doing anything and allowing this man to essentially suffocate to get death inside of that suitcase. First of all, not an argument that I think is going to go very far with jurors to begin with. Thank you so much, Cajun Girl. Especially when jurors see that videotape. So we're already into the grasping at straws area of defense work here when they're making this self-defense, battered spouse syndrome argument here. But also, they realize, and I think the reason why they're going with this defense is because of the videos. They know the videos are getting in, and the videos show her laughing and taunting and sounding intoxicated. But another thing she talks about is, this is for what you did to me. Words to those extent. This is for what you did to me. This is how it feels when you choke me. All of that stuff. So I think her attorney, giving him credit where credit's due, took a look at that, said, listen, if we're ever going to explain these videos, and these videos are haunting and awful, you've seen them a million times. I'm not going to show them to you here now, but it is awful to realize you're watching a murder take place. Something about it is so chilling too, in that you cannot see him, that you just hear his voice and see that suitcase struggle a little bit. Oh, it just gives me nightmares. But they knew they had to do something about those videos, because going into this trial and not explaining those videos is just walking her to the gallows, essentially. So they have to do something about it. Well, I think, again, giving him credit where credit's due, he thought, well, you're at least talking about domestic violence. Let's try to argue that you were so afraid because of the domestic violence that you couldn't move and you couldn't open up that suitcase because you thought he would kill you. And therefore, this is this kind of hybrid battered spouse self-defense argument being made here. Okay, if that's your theory, then what do you do about the statements that she made to police when asked, what was your motive for putting him in the suitcase? And she says, I didn't have a motive. We were having a great time. Everything was good. We were playing around, playing hide and go seek. I drank a little wine. I blame it on the wine. Or during her interview with the responding officers, and she's talking about, I wasn't mad at him. There wasn't, I mean, she's so eager to tell them that there were no problems between the two of them. And she runs away from any comment about, I was in fear for my life. So are you guys seeing how these two things don't match up? She's either got to get rid of the videotapes that she took on her phone. Not going to happen. No argument there. Or get rid of her interviews if she wants to pursue this self-defense argument. It is absolutely heartbreaking and haunting. Thank you, Cynthia. It is really hard. So that's what you're left with, is he's got to somehow keep this statement out that she gave to police. And the best way and easiest way and strongest argument he has is Miranda. I'm not saying it's a convincing argument, but it's Miranda. Now, his argument is that she was advised of her rights, but for one little sentence at the very end. And I've said this before, Miranda is not magic. It is not like you are Harry Potter conjuring a spell and you have to use the magic words in a certain order for a Miranda to be invoked. Miranda stands for a proposition, for a concept that people must be advised that they have certain rights. Only if you intend to use their comments in court, by the way. Doesn't mean it doesn't affect the arrest in any way. And only if that person is in custody and being interrogated. Okay, so they're in a position where objectively everybody believes they didn't have a right to leave, and they're being asked questions, and you want to use those statements in court. Then a person must be Mirandized. And the Miranda warnings, you know, from the case of Miranda from the 1960s until now, has gone through a dearth of case law and been questioned and sent up to the Supreme Court numerous times, so that we arrive at today where we believe that these words that are used, that are put on a card by law enforcement, are fairly safe. Okay, doesn't mean that it's still not challenged, but it's fairly safe. So they read off of this card, and at the very end, it says, with these warnings in mind, do you want to speak to us? And they did not say that exact words. What they did is they questioned her. They advised her. She said she understood. This was also the second time she had been advised. She'd heard all these warnings before. They advised her, and then they just started talking, and she started voluntarily talking. Okay. I don't think this judge, and I've seen this judge now a couple of times, he seems very no nonsense to me. He also seems very sick of her SHIT, and he's not going to go for any of this. But they're going to have a hearing. Fine, good. That's what they should do to avoid any problems in this case. Now, where it became surprising to me is I thought the defense filed their motion, the prosecution will file response, and today all we would see is some argument in court from the attorneys. Instead, they had a full-fledged hearing. The detective testified, and then surprisingly, Sarah Boone took the stand, and that's what we're going to watch right now. So that is the big lead up to what we're going to go ahead and watch here in court, is her actually testifying about her arrest and the warnings and everything else. One little heads up. Well, two, I'm going to try to answer questions as we go along, but if I don't answer them while we're watching, Kaylin's keeping track of everything, and I'll try to get to as many questions at the end. The other warning on this whole thing is that the volume, the sound in this court is awful, and there was a lot of problems with it today. So you may have to turn up the volume on your computer to hear this, and I apologize for that. This is the best we could find. And I apologize that then when you have it loud, when I start talking, you're gonna be able to hear it from the next room away. So just a little bit of warning. Let's begin with her testimony now.
Any further witnesses, evidence, or testimony, sir?
I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn. y'all be here?
Yes, sir. And the deputy's got to move her. And you've already been sworn. We may proceed.
And would you please state your full name? So you're gonna have to speak up or move the mic.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion? All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911? Is it true that Detective Deputy Rodriguez of the Sheriff's found her?
Yes.
What mental state did you have at that time?
Very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with my health. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Judge, when you strike, this is outside the motion to suppress, not make any allegations that the state needs to be voluntary for mental state or state of intoxication. Response?
Judge, we're talking about, I'm just getting some preliminary information. The interrogation is the next day.
The state has an obligation, the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and surprise.
Okay, this is really thorough interrogation.
I understand that.
We're not talking about intoxicated.
Are you going to be arguing anything in conclusions to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
I'm going to sustain the state's objection.
Relating to the intoxication,
Yes. There wasn't any of the three motions that have been filed.
I didn't ask her that. She volunteered.
I understand it. You have to sustain it. I'll get straight.
Okay. All right. Okay. So what's going on here? Just really quickly. You can see that they're already a little bit abandoning their original argument, which was she wasn't properly advised. Now they're trying to say, I was in shock. There was a bunch of people talking to me. I was confused, all of this stuff, which is essentially making the argument that she was somehow mentally incapacitated and unable to give consent or unable to properly waive her advisements and speak to the prosecution, which is another argument that can be made in regards to Miranda. In other words, you can't Mirandize someone who's bleeding from the head. You can't Mirandize someone who's obviously intoxicated. You can't Mirandize someone who's too young to appreciate what they're being advised of. So there are arguments to be made about Miranda and whether or not someone can actually be advised and waive and voluntarily speak to law enforcement. Okay. So they're kind of getting away from, and he might come back to it, but they're getting away from the idea that she wasn't properly advised. Now they're saying she never could have waived Miranda. And But where the prosecution stood up, and rightfully so, is when she started to say, well, I was hungover. Oh, and I was probably still intoxicated, which, by the way, you got to be really intoxicated to be intoxicated the next day still. We'll get into that later, I'm sure. But they stand up and say, we weren't on notice of any of this. And any notice of mental incapacity, any notice of intoxication playing a role in her Miranda argument. Judge says that's true. You didn't advise them. They're not on notice of that. Where are you going with this? Defense says, well, this is from a previous encounter. He says, well, are you trying to bootstrap any of this to your arguments that you're making now? Well, I do plan on talking about how that did affect her later statement, which is the statement they're trying to keep out. Judge says, no shot, not going to let it happen. Objection sustained as far as the intoxication goes. Let's move on. But what this also says to me is this judge is sick of this crap. And he's putting on this hearing, but you better tighten it up, sir. And I'm not going to allow this to turn into a circus, and just get to the point of what you're trying to make. So that's my 2 cents on what's happening right here. She is remarkable, though, isn't she? This person, the psyche of this person just continues to astound me.
Did you speak to the deputy about what had happened? Okay. And then when you asked to stay on scene,
By those detectives, yes.
okay, how long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. The detectives, the two detectives, when they arrived, did they take over the investigation?
Yes.
At some point, were the detectives directing you what to do? And okay. Can you explain what the detectives told you as it relates to you getting in the car? What was the phone issue before the car?
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell them?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
Um,
After that incident, was the next time you were spoken to?
Okay, so what's a little bit interesting here is that's a separate issue of whether or not she gave consent to search her phone. An issue I don't believe is at play here in front of the judge right now. We're talking about Miranda right now, but that brings up a Fourth Amendment issue of whether or not she gave consent to search the phone. And the way she just described it, it sounds like the officer just told her to unlock it. We could go into an entire episode on whether or not that is actually consent. But it is, that is a search, and that is a search you have to give consent to if they don't have a warrant. And furthermore, giving your passcode is essentially invokes a Fifth Amendment issue. On a totally just interesting to me side note here, if you guys have an iPhone, or maybe other phones do this as well, but I'm most familiar with iPhones, that has it unlock with your face as opposed to unlock with a passcode, you can refuse officers to give your phone. I mean, to give your passcode, because that is quote unquote a statement under the law. And being asked to give your phone, you can refuse to, part of your Fifth Amendment rights, refuse to do. But you don't have a Fifth Amendment or any kind of constitutional protection in what your face looks like. So there are cases where officers simply hold up the phone to an in custody defendant to unlock the phone. If you're looking to commit any crimes with your phone, maybe something to keep in mind. That's some free advice. I give all disclaimers that I'm not your attorney, but just a little insight into kind of the weird nuances with electronics and constitutional law. But my whole point here is that this idea of her phone, I don't believe that's at play, but that was an interesting little couple of questions that were asked there of her phone.
Detective Counsel was in relation to the interview in the squad car.
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
She was just going to be asking me general questions.
Was there ever any mention about normal protocol?
I can recall.
Okay. Once you got in the squad car?
Don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read your Miranda rights? All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect? Did they ever indicate to you that you were a person of interest? Did they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
It was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours.
Okay. At some point, did they all leave? And at some point, did they tell you they were finished with the work there at the scene? Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove.
Okay. What was the reason that you wanted to stay over there the night?
Because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband? And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copeson?
I did.
And whose phone did you use?
Husband I knew.
You said your phone had been seized, and you had consented to that. You signed a form allowing them to take the phone. Have there been any discussion about returning the phone?
Hopeful told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do? Was there ever any talk about you coming to the sheriff's department that the day of this event?
I don't know the relevance of most of this.
Your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copeson's private cell number?
She gave it to me before she left the scene.
And did you call her? Do you recall about what time you called?
I believe it was around 9:30 or 10 o'clock.
So that would have been on February the 24th of 2020? All right, can you tell us why you were calling her that night?
Before she left, gave me her personal cell phone number. She told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no any question at this time.
Okay, you were concerned about the case and you wanted to call her. And did you talk to her? What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Objection. Irrelevant. Sustained.
Yeah, this judge is just done with the nonsense. This is one of the by the way, usually when you have a hearing where it's just the judge will be far more generous with allowing stuff in, because the judge knows the only one who has to consider it is himself. So if he hears something and he feels it's irrelevant, he's just going to not think about it. The reason why a judge becomes a little more, tight with his rulings is when there's a jury present, and unringing that bell becomes far more difficult. So I've had many hearings where you make objections and the judge goes, that's fine, keep going, because the judge knows I'm not going to consider that. And I don't want to get in. I just want to get through this hearing. But this judge is, standing there at the ready with his evidence code, and anything that sounds like it's outside of the bounds, he's not letting in and sustaining that. And it's, to some extent throwing the defense attorney off his game. But to me, a lot of this is just kind of under reading the room. This judge is not having this and wants this nonsense over with. Trial starting. He's not going to let this trial get derailed.
Did you have a conversation about your phone?
Yes.
Oh. You can answer the question now.
Yes.
Did you have a discussion about your phone?
Yeah.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was getting pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my son.
Was there any discussion about you being interrogated at the sheriff's department? Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone? And
Okay, just quickly, if where they're going with this is that the police use some sort of ploy to get her to come into to the police department, big whoop. Not getting them anywhere. Police use that all the time. They're allowed to use it. In fact, in many cases, they're encouraged to use it because it creates a safer way of getting someone into the police station than rolling out with squad cars and saying, you're coming with us. Somebody voluntarily going into the police station is just a lot safer for everybody involved. So this whole idea of, they set me up on, she said she was pregnant and wanted me to come in, and I was just trying to come in to get my phone, and they ambushed me with this whole police interrogation. Not going to fly, not going to go anywhere. And this whole hearing is starting to reveal itself to me as being just a grasping at straws attempt to see if anything will stick with this judge, which leads me to believe that woman right there is probably the one still calling the shots on this.
the reason for the change in plans from them bringing the phone to you was because Detective Cupsell was pregnant and not feeling well. So the next afternoon, did you drive to the sheriff's department? Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, ran them upstairs, and Detective Lowen came downstairs And I thought I was supposed to be picking my phone up over at a particular window. And he said, no, your phone is upstairs. So we were just wanting you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
Did
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants.
His firearm was on his waist?
Yes.
Okay, so y'all got off the elevator, where did you go from there?
He brought me into the and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Yeah, okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room? Okay. So directly off the elevator and walked into the interrogation room. And then we've got the video on that. Now, you and I've watched the video, correct? And you've seen the motion where I referred to the question where she asked you to sit down.
Yes.
You recall that happening? Did that refresh your memory watching the video? Do you recall her saying that she had received the autopsy?
Yeah.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy? This was prior to you being read your Miranda rights. And she also said, we're not done talking about the incident. You recall that? And then she said, we just have to do it. How did that make you feel?
Good. Yeah. Who cares?
Were you trying to comply with the officer's demands? And were
In every way.
you trying to cooperate? Were you polite with him? And when she said that, we just have to do it, you said, just like we did yesterday. And then you said normal protocol. Is that what she had said the day before? Normal protocol. And she said the same word. You said normal protocol. To her.
I would reiterate to her what she had said to me the day before.
So she read the Miranda rights.
What are we doing here? What are we doing here? This is honestly making it a stronger case for she was properly advised, but I don't know what we're doing here. Is this supposed to be a I mean, you know, she was coerced, tricked into speaking to the police again, yet she was trying to be cooperative. She was trying to be helpful. Nowhere in this do I get any idea that these Miranda warnings are somehow deficient. And nowhere in this do I get any idea that the police had held her down and forced these words out of her mouth. Maybe it was a test by Owens who wanted to see. Wow. Kat, I like that. Thinking outside of the box. Put her on the stand, see how she does when she's not in front of a jury. Interesting. Okay. You know what? I hadn't thought of that, and I like it. Way to go, Kat.
To you. Except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had. But you were not read having these rights in mind. You agree to speak to me now. Over.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, did she read right into the question? So she never got the answer from you. Do you agree to speak to us now?
Is that rest that?
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody.
Yeah, it's been conceded by the state in their response. There was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What is her subjective perception?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to whether or not.
She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her.
Oh
position
boy.
was that she was coerced in answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens at a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being non-compliance with Miranda, coercion, or the third ground of voluntariness.
Well, I think it goes subjectively to her what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objections overruled. I'm sorry, the objection sustained. I apologize.
You remember the Wile E. Coyote cartoons, and they go off the cliff, and you just see him just falling forever till there's just this like puff of cloud of dirt that puffs up at the very bottom of the canyon. That's what I feel like we just watched in real time here. I feel like he just realized the custody is not at issue here, which, by the way, it's not, and that's why they Mirandized her. The judge is being respectful and giving him, as much rope as he wants to kind of hang himself here, but he was trying to establish that she was in custody, which has been conceded by the prosecution and accepted by the judge, and nothing that any of us are dealing with. And so he's saying, he's asking the same question I'm asking. What are we doing here? And he doesn't seem to have an answer other than he wants it. It was almost like he's trying to shoehorn custody is per se coercion, which it is not, and which is not the argument being made here at all. She's in custody. She's being interrogated. Everybody agrees to that. That's why ... she was Mirandized. Had she not been Mirandized, maybe this would be a bunch of arguments that are ripe for the picking, but that's not the point here. And again, I'm not trying to throw people under the bus, but it seemed like he realized that in real time as he was clutching that podium for dear life.
Did you understand you were not going to get your phone back until you answered the questions?
Sustained.
Did you have some questions for them at the end? Did you feel like you had a choice in answering their questions?
Sustained.
And that day, You came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
did not,
Did you know that you were going to be arrested?
did not,
Did you know that you were going to be questioned? Were you trying to cooperate with law enforcement based on three statements that you have to talk to us? Or were you there answering the questions because she confirmed that this was normal protocol?
my understanding is,
That's all the questions.
Yowzer.
Termination.
Wowzer. That went all of nowhere quickly.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct? You were impaired by alcohol, correct?
I don't know as much as it means, it did, yes,
Okay. And that is consumption from the night before, correct? So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
ask it one more time, please.
Did alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon? Then,
Did alcohol affect my conversation with her?
there's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory and perception of the events that you testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect
Oh, you're not confused, lady.
my answer?
Judge, I don't think she-
Affect,
I don't.
answer. What do these words mean?
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she didn't know what it
What are the legal grounds of your objection?
Yeah.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years? Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Finish. I'll object to that.
Sustain the objection. Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
I'll object to that. I'm not understanding what the question.
Mr. J. Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison based on the examination that both state attorneys and defense counsel and the state's expert witness today. Is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all of the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon. Response.
Judge, I agree with the impeachment about being under influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison plus 22 years on the low end. I agree with all that. We just got through the jail, meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, and he's free himself. I don't think that's proper cross-examination about what she said there versus what is saying here.
Anything further? Mr. J. I'm not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded. So I'm going to sustain the objection based on how the question was asked. I'll let you revisit it based on how you just explained it to me.
This did not go how I was thinking it was going to go. This, first of all, honestly, I think the prosecutors should have just asked no questions. I mean, this hearing, as far as what they're trying to accomplish, they did not accomplish. If anything, they might have strengthened the Miranda warnings. But he gets up and he starts asking questions. Fine, go for it. Then I think he's obviously trying to pin her down. This is prior testimony. She's under oath. If she does intend on taking the stand, to pin her down to a certain narrative as far as her intoxication. But now he's gone off on this interesting argument of, you are in fact a liar, ma'am, because you know you're going to prison for the better part of your life. And therefore you have a bias to lie about what took place previously to get these statements tossed out. It's an interesting argument. I mean, but what they're all dancing around is that it's only important if she then testifies at trial, which she has a right to reserve any question on until later. I don't know. I feel like the prosecutor's playing with fire a little bit here. I like what he's doing. I think it's clever, but I think he's playing a little bit with fire. He really should not be getting into, the idea of whether or not she's going to testify and whether or not he's somehow affecting that now by, I don't know. It's getting a little weird and a little messy. And it's like, it's fine if he wants to nail her down to a story. But this whole idea that I'm impeaching her as being a liar because she knows she's facing a murder charge is a slightly nuanced, different thing than just calling a defendant on trial at jury. Well, aren't you lying because you don't want to go to jail? But I don't know. I'm still in a fog as to what's taking place here, and I'm trying to work it out in my own head as it's happening, but it's fascinating stuff. I think he did get, Afton asked, did he getting good impeachment stuff? Well, he got her nailed down on this idea of intoxication, or he was starting to. And I think he's trying to nail her down to some of the circumstances surrounding when she was giving these statements. I thought he was going to go nowhere near it, but he's decided to go ahead and pin her to a narrative. And the judge was allowing it, even though it was really kind of immaterial before. But here we are. Here's where we find ourselves.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020? And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Wow, this is weird.
No other questions? Redirect examination. Okay. We can have this been returned back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
arguments.
Okay. Anything else from the state other than argument?
Just argument.
Okay. Fine. Once Ms. Boone is seated, we can proceed with it.
Okay, we'll get into the arguments, but just I don't know what that last little dance was there. I don't know what point he's trying to make. I mean, I know the point he's trying to make, but I don't see the 3D chess he's trying to play with the idea that you gave a statement, you know now that it's in your benefit entirely to keep that statement out because you're trying to avoid prison, which I guess is just always kind of a factor when a defendant is testifying. But he wanted that point made now with this judge. I don't think the judge is going to care all that much. We're here to talk about Miranda, but okay, shots fired. Everybody seems heated up. Let's see how the arguments go on this whole thing. This case is so weird. I guess I shouldn't be too shocked that it got even weirder, but here's where we find ourselves.
And as the court previously, I have reviewed all the authorities that were provided. If your officer motion, sir, you may proceed.
It's my understanding of the law regarding Miranda.
Oh boy.
First issue was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. Now, I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found another weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, they can be utilized to obtain a confession or admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental.
I don't know where he's getting that from.
To incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kupsel on the one hand I got to read you your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that should be allowed or is allowed. There's nowhere in the law that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to. Before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It takes the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
Boy, babe.
The statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why do we even have it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking that Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be a valid waiver of her rights under that circumstance. Coupled with the fact that she came down under false pretenses.
This is just a tap dance.
In fact, she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer. Those 3 or 4 questions, and then, do you understand what I just read to you? I'm paraphrasing. But the detective Copso goes right into questioning. Once Sarah says, yes, I understand. It's an acquiescence to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah. To be given that opportunity. But the way I understand, Detective Copso had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information.
I think you can all tell how this is going by the furious notes being taken by both the prosecution and the judge. Oh, wait a minute. Both of them have their pens down. No one's all that concerned with what's being said right now.
And she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt with one statement. She'd already said we had probable cause. We'd already made our mind up and we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke All right, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could let her use. So they're trying to do well. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Yes.
Any response?
That was just a tap dance. I got
The
nothing.
United States Supreme Court has said that confessions are good. They're good for society. It is good when guilty people are convicted. We stand by the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2 hour and 6 minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Thank you for the argument, Mr. Owens.
Just want to point out how the prosecution went up there without even a Post-it note in his hands to make that argument. That is what we call, we all wasted our time, Your Honor. And can we get out of here so that I can still make my dinner reservations?
The court has had the opportunity to review all the case law. Court's going to put it in order, and you'll have it before the close of business tomorrow. Courts may be closed, but I'll be here working.
But for the record, there's 2 exhibits that I tried to introduce. They will be admitted to the record.
Yes, of course. They will bring marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing
Oh, God.
without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
So you guys want to, do we need to get into the hair and makeup? I don't know. I do know that was denied, sorry, spoiler alert on that whole nonsense, but I don't know if we need to waste our time further with this whole tomfoolery about whether or not she gets to have her, what do they call it? Hair, what do they got a term for it in the industry when it comes to hair, glam, whether or not she gets glam done before trial. But I'm surprised the judge took that under advisement. I think he wants to make a written ruling to just make sure that everything on this holds up on appeal. But I mean, what I saw there was, Owens, I'm not gonna beat up on this guy. He's got one of the more difficult jobs in the world, defending this person and trying to do it in front of the world's biggest stage with everybody watching and just criticizing everything he does. But that was a bit of a miserable motion. There was nothing there. There was no there. I thought the argument was going to come down to the importance of her being asked and whether or not that, and that might have some merit to it, that, yeah, you can advise someone, but are you letting them know that questioning is starting now? Or do they have a moment to reflect upon those rights before we get into the questioning of this person? Maybe there's some argument, something that could be fleshed out and all of that. But the idea that this whole came down to, they tricked her, Your Honor. They were tricky. They were too tricky. And we can't allow this to happen with all their trickiness. Come on. I mean, And again, I don't know where he was going with the idea of they're only allowed to use subterfuge after she's been advised. I don't know any case law on that. They can trick you to come in to the police station. They can tell you, that they just want to simply talk to you. I mean, this happens all the time where they are your best friend till you get into the police station, and even your best friend when you're in the middle of that interrogation, and then they just start to turn on you after you've already given some statements. Miranda law is a fascinating area of criminal law, and I might even do an entire video on that if you guys are interested. I don't know if you'd want to sit through half an hour of discussing it, but there's a lot of interesting stuff that law enforcement can do, even with Miranda. I mean, there's even instances where you can have an entire statement given without Miranda, and then they can say, okay, let's take a moment. I'm going to go ahead and advise you of your rights. And now I'd like to talk to you again about what you just talked to us about. And at that point, people think that, well, they've already told them anyways. What is the harm in telling them now again? A lot of case law dealing with that and when that's appropriate and when it's not. But this whole idea of she just was in there to get her phone. She didn't know she was a suspect. She thought they were just returning her phone. I'm sorry, but you saw, by the way, a fairly intelligent woman take the stand. And that fairly intelligent woman was advised of her rights. And that fairly intelligent woman indicated she understood all of her rights. And she decided to sit down and speak. And at no point during any of that conversation did she say, I don't want to talk anymore. I want a lawyer. And now, only realizing this cockamamie defense that they're about to give, does she decide that she wants this statement kept out? I don't see the judge doing anything about this. That statement's too important. I don't think he's going to undercut the entire defense or prosecution case here on that weak of an argument. And I think if there's any indication by his behavior in court and everybody else's behavior, he's not going for it. So, all right, who you with? If you want more Miranda, I got Miranda to your bleeding from the ears. So maybe we'll work on that and get that to you sometime soon. In the meantime, Kaylin, do we have some questions? I know I kind of didn't get much of an opportunity to ask some of them. I prefer a 10-episode explanation. You're getting it, defense attorney Meow. You will get 10 episodes, an entire the rise and fall of the Roman Empire treatise on Miranda, if that's what you're really asking for. Simi Sharp says, if you were Sarah's attorney, what line of defense would you suggest? I think that the defense is built in. She sounded intoxicated on the tape when she's videotaping. She says, the first thing she says is, I was intoxicated. I can't remember. I woke up. I didn't know what happened. I think there's a built-in argument of she never intended for him to lose his life. And that, yes, at the end of the day, I intended him to learn a lesson. And if she wants to testify to that, that's probably a far more persuasive argument to even make to the jurors if she were to testify. Now, the problem with that is that doesn't get her out of criminal liability and it doesn't get her out of prison. And at the very best, it might get her some sort of involuntary manslaughter, but it's still putting her in prison for a very long time. And I think she thinks to herself in her ego and narcissism that she's going to shoot for the moon and see if she can't get out of this entirely with this self-defense argument. But great question. Kat says, why would this attorney pick up the case and then go this route? Why would he pick up the case? Number one, I don't know. A lot of people talking about he's just looking for publicity. Maybe he is. Maybe he's up for the challenge. Why would he go this route? I think she's still the puppet master in this whole thing. I get making lemons, but the case wasn't forced on him. And let's be real, this is a bad plan. I think it is a bad plan. I think that this is not the type of client where you sit down and you go, listen, I understand what you want to argue, but what you want to argue is hot garbage. And I'm not going to stand there and make that argument. I, as your attorney, make strategic decisions. You have the right to control me over some things, but maybe they had that conversation with 8 prior attorneys. And that's why they're all gone, is she wanted to pursue this desperate defense. And maybe the only way she would allow him to represent her, the privilege of representing her, was if he went along for it. Again, as a defense attorney, I have a little sympathy for these guys when they're put in these situations, because sometimes you're just working with the facts that you have, but this is not a winning argument to me. Yeah, a lot of people are saying that, Kathleen, that he picked up the case for publicity. Maybe he is. I don't know if he's getting entirely the publicity that he wants out of this, and I don't know how much great publicity it is going down with a sinking ship. Taryn Dusty says, can the state use her past arrests in this case? I know George's past arrests were mentioned today. That's a great question. I think there's an avenue for where it would become relevant. Usually you're not allowed to just get in prior arrests and prior bad conduct unless it qualifies under certain theories of, common plan or scheme or motive or everything else. Here, there might be an argument of she cannot now claim that she didn't have any sort of animosity or ill will towards him, having demonstrated that through her own arrests in the past. But I think the defense might open up the door just by saying cycle of violence, that it would be a counter argument to that for the prosecution to say, well, yeah, he was arrested and he had been violent towards you in the past, but you had also been violent toward him. Isn't that true? And it certainly will become admissible if she were to take the stand and they wanted to impeach her with it. Yvonne McLaren says, if she is impaired, can she legally give consent? I think that's where the prosecution was trying to clear things up with what level of consent and what day did that take place, and was she claiming, because she was claiming she was intoxicated, I believe, when she was first contacted, but not the follow-up day when she went in to, quote unquote, retrieve her phone, which is the subject of this hearing right now. So I don't think she's making a claim about whether or not she was too intoxicated or impaired to give consent. If you're talking about consent for the Fifth Amendment issue at this point, even though, to answer your question, yeah, you can be too impaired to waive your rights, your Miranda rights. But if you're getting back to the consent to search her phone, that's an entirely different issue that I don't think was before the court here, because I don't think they're going to, I think they feel even that might be a bridge too far as ridiculous arguments to bring up in front of this judge. I like this judge, by the way. Defense attorney Mao says, did it seem like the phone seizure was a little sketchy? No. I thought maybe they would explore that more, and I'm surprised with this kind of throw it against the wall, see what sticks mentality they seem to have in this case, that didn't become more of an issue. Police were going to seize that phone. That was evidence. Now the question becomes whether or not, and they were seizing that evidence, incident to the crime, incident to arrest, whatever else. I don't think that would be an issue, but the telling her unlock your phone, there might be some room there for defense argument that, hey, she wasn't advised that she could refuse to do that. Now, police, oftentimes say, step out of the vehicle. I'm going to take a look inside. Okay. And you're giving consent at that point. They are asking for your consent to search your vehicle because they don't have a right to do it at that point. And many times people just go, oh, sure, because it's the cops and they're wearing the badge and the gun. And they think, I have to say yes. And that argument has been made countless times and rejected countless times. Here, did she feel that she had the right to refuse to give the passcode to open the phone? Might be an issue that wasn't explored, that might have some argument to it, but again, they didn't bring it up, so who knows? What else we got? Let's take a couple of more before I get yelled at by my wife and kids to come be a father again. This is Creative Mind says, does this give you vibes of a possible plea? I don't think so. I think if they've come this far, I mean, crazier things happen. He may be having some very, very serious conversations with her in lockup this evening about, look at, we tried your stuff. We tried to get it kicked out. The judge is not going to kick it out. Certainly if the judge gives this ruling, he says by the end of day tomorrow, and it comes back that no, that is coming in, and they realize, and she finally sees the writing on the wall of how this is, their entire case is headed directly off of a cliff. Maybe they then begin to talk about, now's the time to take a plea. But I see from everything that she has demonstrated up until this point, a very pridefully obstinate and entitled person who I think wants to see this to the very end. Plus, if she doesn't, then how is she going to have her moment with her hair and makeup done in front of the entire world? So I think she enjoys all of this attention. Lee T says, Josh, have you ever applied makeup on a defendant before in court? Great question. I wish I had a more clever, funny answer to this, but no, I have not applied makeup in court for a client. It is very funny to me that became such an issue in this. And by the way, let's just take a step back and say, would that even be helpful to you, lady? I mean, don't you want to look a little bit more kind of embattled than someone who's got their hair and makeup done for court? I don't know how she feels that will somehow be persuasive, but when you're a narcissist, you're not thinking that way. Jocelyn Christensen says, can prior bad acts be presented if they're within a certain time frame or similar to the current charges? Yes, that's the point I was making before. There are instances, there are exceptions to allowing prior bad acts in if they basically the whole argument comes down to proving things other than propensity. In other words, you cannot bring in a prior act of domestic violence. Now, California is different, and some jurisdictions are different. To say, hey, even if you don't believe this person committed abuse on this occasion, look at the other times they committed abuse, and this is an abuser and has the propensity to commit abuse. Therefore, you believe that this person committed abuse on the charged crime in front of you today. These are the types of arguments that cannot be made because it's talking about propensity and character evidence. California, some jurisdictions are different and that you can absolutely argue that. So I don't know if that's really going to become the issue here, because as much as they're trying to make this into a domestic violence case, this really to me is just a murder case. You had a person begging for their life and you did nothing about it. And you just essentially not only watch that person die, but were too bothered to even watch it happen that you went to bed and fell asleep and woke up the next morning. And the first thing on your mind wasn't, I wonder if George is okay. The first thing that you did from what she said, she woke up at 11:30, didn't get out of bed till 1, or didn't call anybody until 1 o'clock when you realized he was dead. So you woke up and then just sat there scrolling on TikTok before you even troubled yourself to find out if the man that you had left zipped up in a bag on your living room floor was still alive. Good God, talk about the narcissism and calloused heart of this person. And that's exactly the arguments the prosecution will be making in this case. All right, let's take one or two more. Kat says, Josh, have you ever thought, what are your thoughts on law enforcement being about to deceive suspects to the extent that they are currently able to, especially you coming from both sides of this, of the scale? Yeah, I understand it. And I feel that it is something that we cannot make a hardline rule on, that they can never deceive someone. But I do think it is an area of the law where there should be certain scrutiny given to it, because, it's one thing to say, hey, we've got you on videotape, and then somebody admits to it. But, I think it's another thing, and I'm trying to think of a good example where that deception might turn into coercion. Really playing upon the emotions of someone so that you might feel like you're pushing it to the point of getting a false confession. to answer Kat's question from the other side, I do believe also that false confessions take place. As hard as that is to believe, I do believe there are 4 real instances in real life of people giving false confessions because they just felt like they had no other way out. And this was the best thing for them to do to save themselves or their family in that moment. And people are just, there's a lot of unsophisticated people who will be caught up in that situation. So when you talk about deception used in that type of a scenario, that's where it begins to be a little bit more problematic for me. All right. Guys, thank you so much. Again, you're all fabulous for being here with me. I know it's getting later on the East Coast. A couple of quick announcements before we close this out. But remember, we had our 5 things on Sarah Boone that came out Monday. This trial, I believe, is starting. So if you want a quick refresher on everything you should need to know about this case going into it, please check out that video. It's out on our YouTube channel now. And please stay tuned for this coming Friday episode where we will get into all of these things that we kind of touched on tonight, missed out on tonight. It's our weekly tune in. Check it out every Friday on Courtroom Confidential. In the meantime, I hope you all have a pleasant evening. You're all fantastic. Thank you for being here with me. And I will see you again next week at the very same time. Take care, everybody.